there. We should have Ms. Jocelyn representing Sarah Williams. I see Ms. Jocelyn. And
Good morning, Your Honor.
Good morning. Is your client, Ms. Williams, here today?
She is, Your Honor. And I believe Mr. Williams is also present on Zoom.
Okay, Mr. Williams, are you there?
Yes, Your Honor, I'm here.
Okay, great. Welcome, everybody. So we're here today for a presentation from a hearing that we held last week on June 13th. And I see that Ms. Jocelyn had filed a proposed order and that I was just handed a proposed order from Mr. Williams. And so I'll just take a quick look at Mr. Williams' proposed order, and I'll ask
Goodness,
if you received a copy of that.
Yes, we did, Your Honor.
Okay, great. I'm just going to take a quick look. The order pertains to the reunification counseling. And so there's a couple of items that I noted that I think need to be adjusted a little bit. We didn't specifically talk about cost at the last hearing, so that's something we need to talk about here today and finalize that. And then let me just take a look. I made some adjustments to the proposed order that Ms. Jocelyn had provided, but now I'm looking at Mr. Williams. I just need to digest that for a second. Okay, they both have merit, and they just touch upon different things and put an emphasis on separate items. So what I would like to do, if the parties could focus on the proposed order that's been put forth by Ms. Jocelyn, and I'm just going to direct your attention to a couple of different lines, if we could please. Start off, the reunification therapist shall receive input. So I wanted to add to that language. So it'll start off, the reunification therapist shall receive input from Silas's therapist, Desiree Mansauer, and Mr. Williams' therapist regarding the readiness of each. So I was adding that language. And Mr. Williams' therapist regarding the readiness of each for reunification or any other issue pertaining to reunification. And then striking deems necessary, or what Ms. Mansauer deems necessary. And then it would continue to read, the reunification therapist shall receive input from the domestic violence treatment program with Dustin Williams.
Changes made, Your Honor.
Pardon me?
Changes made, Your Honor, so far.
Then I'm looking at line 18, where it begins reading Silas's therapist and the reunification therapist. And this is language to add after the word reunification therapist, and Mr. Williams' therapist, to set a plan for reunification.
Okay.
And then it goes on, the reunification between Silas and Dustin together may commence when the reunification therapist deems appropriate. Okay. And then line 20, should it read, that's where it starts off, Silas's therapist may continue to provide. I'm hoping to add where it says Silas's and Mr. Williams' therapist may continue to provide input to their reunification therapist as often as needed.
Thank you. Your Honor, should we also, because we reference 2 paragraphs up, should we also add the domestic violence program as well to that sentence?
On line 20.
Because
Right. Okay. Mr. Williams, do you have any input on that?
I just wanted to know which therapist she's referring to.
So we're looking on her proposed order, line 20 of page 2, where it says Silas's and Mr. Williams' therapist may continue to provide input to the reunification therapist as needed. So
Gotcha.
You see where we're looking?
Yeah, you're talking about my therapist.
Yeah, we're adding Silas's therapist and your therapist may continue to provide input to the reunification therapist. And then Ms. Jocelyn was suggesting that the DV treatment provider could provide input also. Kind of I think that Ms. Jocelyn's point was to not only say kind of give input at the beginning from the domestic violence treatment provider, but also kind of on an ongoing continuing basis.
Okay, I just was confused on which therapist she was referring to.
Oh, okay.
Which of my therapists? Or is she referring to Stacy? Or is she referring or which actual therapist of mine?
Yeah, that's a good point. So I mean, line 20 probably should read Silas's and Mr. Williams, regular therapist and domestic violence treatment provider may continue to provide input to the reunification therapist as often as needed.
Okay.
Great. So now we've taken care of that. I just want to talk to the parties about the issue that we did not discuss last time as far as cost related to the reunification counseling. Ms. Jocelyn indicates on line 14, Dustin Williams is responsible for any and all costs of reunification. Mr. Williams' proposed order says that the parties are responsible for their split portion of any reunification costs. So differing opinions there. So I'll hear from Ms. Jocelyn, then hear from Mr. Williams.
Yes, Your Honor. According to their child support worksheets, they are 37% Sarah, 63 Dustin, just for Your Honor's reference. And we acknowledge that wasn't in order, but I thought we should address it so it's not left. Sarah's position is that Dustin is solely the person who caused the situation. He is the one who should be responsible. The protection order just got extended for another 2 years on Friday. Sarah and her family are providing free supervised visitation. So Dustin is not incurring that cost. He very well could be incurring supervised visit costs every single week, and he's not. So with that, combined with that's his issue that while we're here, and additionally, he is over $900 behind in therapy reimbursements to Sarah. Granted, he only received the request last week. So based on those three things, he should be solely the person to pay for the cost.
Thank you, Ms. Jocelyn. And you indicated that the percentage you said 37 and 63. I missed who was the 37, who's the 63.
Oh, I apologize, Your Honor. 37% Sarah, 63% Dustin, and that is from the worksheets filed December 3rd, 2019.
I just think that we should have a shared cost in the child support worksheets, like in our final parenting plan. I agree with the $900 that I haven't been able to pay just yet, but I sent Jennifer over a breakdown on what I can afford. I have just monumental amounts of attorney fees and stuff like that, because if we go back to the beginning, like Jennifer said, I did not cause this. I asked Sarah what had happened and where Silas was.
Your Honor, I'm going to object. I said Dustin is the one that caused this. I didn't say he didn't cause it.
So the objections and so I think there's just a differing view of this. So I'll allow Mr. Williams to finish. Go ahead. Go ahead, Mr. Williams.
So I just, in the beginning, when Sarah started all of this, I was messaging her asking where Silas was, and she was telling me he was sick. And then, she filed the protection order, and then now here we are 300 days later. I don't see Silas but for 2 hours at a time. I spent the first probably 200 visits or 200 days that we didn't see him. I think it was like 30 weekends that we paid for supervised visits, and it was almost $300 every weekend. That was $1,200 a month just to see Silas for a couple of hours on the weekends. I've tried everything I can. I'm working 60, 70 hours a week. I've also got 2 daughters, one of them 7, one of them 3. We've also got a new baby on the way that Silas is very excited about. We just took him fishing this last weekend. I just wanted to propose that we share the cost, like as proposed in our child support worksheet in our final parenting plan, the 37%, 67%. I agree with that, but me solely paying for the whole entire thing just doesn't seem ethical or fair, because I am trying my best personally to keep my head above water right now. So.
Okay. All right.
We just have a quick comment, Your Honor, regarding the supervised visits. Again, Mr. Williams is not telling the truth to the court. He's only paid a handful of weekends for the supervised monitor. It's been since March since he's had one. Miss Duffy's not doing it anymore. Sarah has been having her mom mostly, and her friend Ashley Folk do it. So he has not spent the first 200 days with a monitor. That is incorrect. He has barely spent anything on a monitor. He is the one who choked Silas. He's the one who has a protection order. He is the one who has a protection order extended for 2 years. He is the one who caused this situation. Yes.
There was an objection raised, and so I just need to hear the objection.
Well,
I'm not the courts, Your Honor. It's been like 37 visits, and she
Okay.
said March.
Mr. Lynch, I apologize. So usually when an objection, there's just a short, succinct reason for the objection. I rule on that. If there's disagreement with what's being said by the other party, then you'd have opportunity when she's finished to share that information. It's human nature to kind of jump in and address those points with which we disagree, but I'll allow her to finish. And then if you have any disagreement, then you can express that when she's finished.
Okay.
Ms. Jocelyn, go ahead, please. Oh, Ms. Jocelyn, you're muted. Sorry.
Apologies. As we've seen time and time again, Mr. Williams is not forthcoming to this court. He just made a statement that for the first 300 hours, then he said 200 days, he has paid for a monitor. That's not in fact true. And so him saying, look, I spent all of this, certainly if he wants to file a motion after, if your honor makes an order that he is to pay and can prove all of these expenses, but he hasn't paid for 200 days worth of monitor. My client's family has volunteered to do it, so he doesn't have to have a cost. They've done it so Silas is more comfortable.
Looks like your mute went on.
Oh, I don't know why.
You're pressing the space bar maybe, or looks like it's muted again.
It keeps hitting mute. I'm going to stop touching things. Basically, the short point is there's nothing that shows that he has spent the first 200 days with a monitor. He hasn't filed anything. It's simply not true. My client's family and friends have provided a monitor for Silas, and so he doesn't have to incur a cost. He is the one who put this family in this situation. He should have to bear the cost of reunification, especially in light of the fact that child support's never been adjusted. He owes over $900. And when he says he sent us a plan to pay back the $900, it was like $42 a month. Sarah is incurring hundreds of dollars a month already in therapy by herself. He should have to solely pay, or at least solely pay it up to a point.
Thank you, Ms. Jocelyn. I'll give you just a few moments, Mr. Williams, to respond.
I apologize, Your Honor, for her misunderstanding me saying 200 days. I just meant it was 200 days, and then that was 4 weekends, so I don't know, 50 days or so that I paid Miss Duffy. I have all the records. I have all the receipts. I can provide those if need be to Your Honor, showing that I've paid that stuff. I'm not Scrooge McDuck swimming in money. So I don't understand how she can bash me like this and tear me down as far as like I'm doing my ultimate best as a father. I just am doing everything I can to try to reunify myself. I'm ready. I'm willing to change. I'm ready to be here. I don't understand either how it's relevant for Miss Mansauer if she's already said that Silas isn't ready. Isn't it up to the reunification therapist to gauge Silas and to decide that whether or not he's ready?
Yeah, and that's why we changed the language in the order, is that the reunification counselor is going to be guiding this. Ms. Mansauer is not guiding this. The reunification counselor will receive input from all parties, and then that counselor will make a decision on where to go. Ms. Mansauer doesn't drive the bus on this one. Okay.
And then I would feel a lot more comfortable with the 67%, 37%. I mean, that's something, ethical that I could afford. I have also 2 daughters to take care of. It's just Sarah and Silas. And I sent her the worksheet on paying back whatever therapist fees that Silas is incurring. I didn't even know that he was in therapy in the beginning. So I'm just trying to get caught up with everything on my end. Also, I have, $5,000, $6,000, $8,000 in attorney fees that I'm paying. So I'm doing my ultimate best.
Okay, thanks to each party for your input. So obviously the concerns raised by the episode that kind of led to the relationship being strained and in the situation it is currently didn't involve Ms. Williams directly. Mr. Williams and Silas, the horseplay that went too far was kind of what led us to this position. So the relationship between Silas and his father is obviously important for the well-being of Silas. Mr. Williams will always be his father and vice versa. So that's not going to change. And so all children have a desire to please and be with their parents. Even if situations are horrific and horrible, there's just that connection. And so building that relationship and making sure that relationship is strong and healthy is in everybody's best interest, which is focused on Silas. The relationship between Silas and his mother is obviously important also. So I'm going to impose the reunification counselor costs will be a 70-30 split. Mr. Williams will bear 70% of those costs and Ms. Williams will bear 30% of the costs. And the reason I'm doing that is that there is for the benefit of Silas, which obviously is in Ms. Williams' best interest, that he have a healthy and be well-adjusted relationship with his father is in everybody's interest. So that's the rationale for the 70-30 split. So that could be added to Ms. Jocelyn's order. And Ms. Jocelyn, if you could be so kind as to email that revised version to Mr. Williams and myself, and then I can print it out and just make sure it comports with what I have here on my notes, and then I can sign it today.
Thank you, Your Honor. Can I just ask one question?
Sure.
Since if what you thought of this, just to make it easier, since Dustin does owe that $900, can we at least say he's responsible until that $900 is paid off? So i.e., if they incur $1,000, normally $700 him, $300 her, the $700 will go toward, you know what I mean? I'm just trying to say that's a way for her to recoup what she's already spent. Like once her portion of $900 has been paid off, then they do the 70-30 split. Because otherwise, like she's never going to recoup that.
I don't agree with that.
So my thought related to the reunification counseling is that when we're here on June 13th, depending on the reunification counselor and their input, the reunification efforts could start soon and should start soon. And that was the court's intent. So artificially placing a barrier by paying that $900 would kind of subvert that intent. So I'm gonna decline that invitation.
Okay.
Within the order.
Okay, we were just trying to find a way to avoid having to file like a contempt or something like that because he's not paying it. So it's our client's now going to be outputting even more expenses when he's not. So that was the only thing, but I understand, Your Honor. I can go ahead and send that order over to you right now. And
you have Mr. Williams's email address also?
Yes, Your Honor. I'll go ahead and save it as a PDF. I will sign it and send it to you. You'll have it as soon as we log off this hearing.
Okay.
Thank you, Your Honor. I just had a question as well, briefly, before we wrap up here.
Go ahead.
I still have yet to get a confirmation on Sarah and Jennifer selecting a reunification counselor. Are we going to go with Charlotte because she's ready to start within the next probably 5 days?
I think go ahead, Ms. Jocelyn.
Yes, Your Honor. We got last week, we got the name of 3 therapists. My client has contacted one, Miss Rosen. She still needs to contact the other 2. Miss Rosen has made it very clear she is not the appropriate one and has actually recommended Landon Poppleton down here, Northwest Psychology. Yesterday was a holiday, so she hasn't been able to reach out to him. So as soon as that, we'll go ahead and send over that recommendation to Mr. Williams. We just hadn't sent it yet. She hasn't talked to him. So my client's moving as fast as we're receiving information from Mr. Williams.
So the court's intent was that if the parties could agree on a reunification counselor, great, move forward with that. If the parties can't agree, then it's noted up on a docket and I'll decide amongst the options. So why don't we do this? Do you think, Ms. Williams, or pardon me, Ms. Jocelyn, that that information could be submitted to Mr. Williams as far as those options, and we could be back here next week and just to review it, just so things move along at a nice pace?
It can, just depends how long it takes them to respond to her. She hasn't even had the chance to talk to the other 2, although I think Charlotte Rosen's more like the head of the sort of the boss of the other 2. I think we need to at least let our attempts out there to try and show it before we just keep incurring more and more costs. Certainly, if we can't agree, we can note it up, but it has been less than a week since we've had those 3 recommendations from Mr. Williams. So my client's going as fast as she can.
Your Honor, I had a face-to-face meeting with Charlotte and I explained the situation to her and I brought all the stuff to her. So part of me is I don't believe Jennifer, as far as her saying that this is not a case for her. She seemed really happy about it. She seemed very, very willing to take on our case. She seemed like, I've been doing this a very long time. I cannot wait to meet you and meet your son. and get some unification going. So I would like to see those emails from Charlotte as far as her saying that she's not the person for it, because I've spoke to her, like I've had a couple face-to-faces with her and spoke to her several times on the phone leading up to this, because I'm willing and ready to change. I'm trying everything that I possibly can to show Jennifer, to show Sarah, to show the courts that I'm willing to do whatever I have to do. If I had $1 million, I would just pay everybody and everybody would be happy and we would all just do what we need to do.
Okay.
Your Honor, it wasn't an email.
I'm not going to belabor the point. So
Yeah.
the court's intent is that this move quickly. It doesn't mean the Reunification Council is going to move quickly, but that the Reunification Council be selected promptly. We'll set this for a review next week. I anticipate the parties will have agreed. If not, you'll present 3 options and I'll make a decision. So we'll see everybody next week, June 27th at 9 a.m. Thanks.
Thank you, Your Honor. Appreciate it. Thank you.
Gonzalez. Ms. Gonzalez, can you hear me okay?
Yes.
Ms. Gonzalez, are you there?
Yes, can you hear me?
Yes, I can. Thank you. All right, so you're present, and then I see that Ms. Holder is here representing Skylar Malinen. Ms. Holder, can you hear me? Okay.
Yes, Your Honor, I can.
Okay, great. Thank you. I'm just double checking in the chat function. There's one of the paralegals from Heritage Law indicated that you're going to appear shortly, and so I think that's where we're at. So let me just double check. So I'm a bit chagrined because yesterday I was here and I was prepping for the docket and I completed my preparations for the docket and I take notes on every single case that I review, sometimes pretty copious notes. And then I'm looking for this case on my notes, Gonzalez and Malinen, and it's not there, which means for some reason I must have clicked that I had reviewed the case, but I didn't. So I didn't review the case. And so it would be a disservice to parties to move forward today. And I apologize. I don't know what happened and why I missed that. So what I'm hoping we can do, and again, my apologies for the inconvenience. I'm sorry. I'm not sure what happened. Are the parties available next week on the 27th?
Let me check my calendar, Your Honor. Yes, Your Honor, I am.
Okay. Ms. Gonzalez, what's your schedule look like next week?
I am fair. Okay.
Again, my apologies, and we will set this over, and I will definitely read and be prepared. That's one thing I pride myself on, and I'm quite embarrassed. So we'll set it over June 27th at 9 o'clock in the morning. So we'll see everybody then. And thanks for your patience.
In that matter, what we have done is both parties have agreed. The opposing party in this case just has not signed the order off yet. So I would be perfectly amenable to doing a set over and waiting for the other party to sign that order.
Thanks. Ms. Holder, do you have any sense of whether it would be a 1 week set over or it would be a 3 week set over because of July 4th?
1 week set over would be appropriate. Both parties are in agreement. I just haven't received the signed orders yet.
Okay. And I'll just double check to see if Ryan Helms is on the line. I don't think he is, but just in case. Ryan Helms, if you're here, state your name. Okay, there's no response. I'm fine with the 1 week set over. Let's see if we can get the signature on that agreed order. So June 27th, 9 a.m. the Helms matter will be set. I see that Ms. Dow is present, and
Okay, thank
she
you,
is
Your Honor.
representing. And do you pronounce it Bjorgi?
Yeah.
Bjorgi. Okay, Ms. Bjorgi is present here, and then Zachary Kochis, are you here?
Yes, Your Honor.
And did I pronounce your last name correctly?
Yep, coaches.
Kochis. Okay. Before we get started, I note in the chat function, there's a chat from Zachary Kochis. I'd like to ask for a continuance if possible in my case. In reviewing the case file, this is Ms. Bjorgi's motion for temporary orders, and I've read all of her pleadings. And then there was a response from the father, just kind of a perfunctory response of disagreement with some things, agreement with other things in the mother's pleadings. And one thing I don't have Mr. Kochis' income, nor a proposed parenting plan from Mr. Kochis. So Mr. Kochis, what's your rationale for the continuance?
Yeah, the reason for that is because I set up in late March a consultation with an attorney, and it just happens to be tomorrow. So I've not yet had a chance to talk to an attorney, and I would like to be represented by one. So that's my reason for wanting a continuance, Your Honor.
And is which attorney are you meeting with?
Chad Zandy.
One more time, please.
Chad Zandy.
Thank you. Okay, thank you. Ms. Dow, what's your position?
Well, Your Honor, we would actually like to go forward today if we could. Mr. Coaches has had some time to at least file something with the court, but I do understand that the court probably needs more information in order to go ahead with this. If we are going to go ahead with it, though, child support is a really critical issue for my client. She was planning on being a stay-at-home mom, and then 3 months after the child was born, she was asked to leave the home. So money is very tight. She's borrowing money to sort of keep afloat. So if we do, if the court does order a continuance, I'd like to make it 1 week rather than 3.
Thank you. Mr. Coaches?
I would agree with 1 week if possible.
It sounds like there's some financial pressures that Ms. Bjorgi is experiencing related to the baby and support. And I need more information from Mr. Coaches, and it sounds like he has an appointment with Mr. Zandi tomorrow. When you meet with Mr. Zandi tomorrow, let him know that we're setting this matter over 1 week to June 27th. And we anticipate that he will have submitted documentation so we can move forward on next week at a bare minimum, the child support issue. So if you could emphasize that to him.
I will absolutely do that. Thank you.
Okay. So Ms. Bjorgi, we'll see you next week, June 27th at 9 a.m. and we'll see everybody then.
Thank you, Your Honor.
All right, thank you. Okay, I don't yet have the order from Mr. Roberts. It hasn't hit my inbox. Ms. Height, has that hit your inbox?
Yes, Your Honor, I just took a peek at it.
Okay, do you have any concerns with it?
No, I do not. I don't have any questions or concerns.
Okay. All right, great. So hopefully my firewall will ease up a little bit and that'll ease into my inbox and we can,
Thank you.
I'll sign off on that with.
Right.
Okay, last one on the docket that I show is the Fowler and Reed matter. It looks like Ms. Fowler is still with us. We appreciate that. And Ms. Looney is present also. Ms. Cotto is not. Madam Clerk, have you received any update from Ms. Cotto via email possibly as to her status? No update. And she indicated that she was on a docket at juvenile. Is that correct?
She had 2 matters.
Okay. Ms. Fowler, what I'm proposing at this point, if at all possible, I'd like to just take a brief recess and reconvene at 10 a.m. and we'll just leave the Zoom up and going and just turn off microphones and cameras, your computer, and wait, and then we'll reconvene at 10.
Yes, Your Honor.
Okay, great, thank you. And Ms. Looney, are you available?
I am, Your Honor.
Great, thank you. We're here on the matter of Fowler v. Reed, causes 18-3-672-08. We're on today for a presentation. Back on June 13th, we held a review related to discovery and the like, and we set it over to today for a presentation of the order. There was a proposed order submitted by Ms. Cotto back on, looks like it's filed on June 13th. And it imposes attorney fees of $250. And it indicates that there is a failure of Ms. Fowler to comply with the court's oral ruling on May 16th and the written order to compel on June 6th to provide discovery. And that when we reviewed things back on the 13th, there was Ms. Fowler had not yet provided any further discovery. And that had not happened since May 16th. And then it goes on to read that Ms. Fowler needs to provide to Ms. Cotto her address under the Washington State Address Confidentiality Program as soon as she receives that information. And that until Ms. Cotto receives that address information, Ms. Fowler would be served through the Calais County Superior Court Clerk's Office. And that Ms. Fowler has the responsibility to check with the clerk's office for any documents or filings submitted by Ms. Cotto on behalf of her client. Goes on to read that Ms. Fowler shall provide full and complete answers to the discovery requests, including all attachments and documents by June 27th. And the respondent is awarded $250 in attorney fees and is set for presentation on June 20th. And the court would review discovery answers on June 27th and would then further consider sanctions if the requested discovery is not provided and is incomplete. Ms. Fowler, did you get a copy of that proposed order?
No, Your Honor, I did not. And I don't know if the state or anyone else was provided that either.
Your Honor, I provided a copy to the clerk's office as per the order the same day I filed it, since I did not have an address to provide it to. I did not give a copy to the state as it really didn't, it wasn't something that involved the state. I believe though I may have scanned and emailed it. I don't recall.
Okay. And Ms. Fowler, did you go to the clerk's office to receive that, and pick up that document?
It is not in the clerk's noting for service. There's no service indicated. So
Did
I
you come
have
to the clerk's office to retrieve that document?
I have not, because I have not seen anything in the filings that there was service of any kind.
So as we indicated a couple of times, just given the current situation until the address confidential program address becomes available and known, until that time, there's an order that you can be served by Ms. Cotto dropping off a copy at the clerk's office, and that's incumbent upon Ms. Fowler. It's her responsibility to check with the clerk's office frequently to see if there's documents that have been ready for her to pick up. So if there's been a failure of Ms. Fowler to do that, and if Ms. Cotto's indicated that she has filed it, which the proposed order was filed, then Ms. Fowler, that's your responsibility to follow through. And it sounds like you didn't do that.
Your Honor, that order was actually filed, and then I left a copy for Ms. Fowler on the exact same day we did it. That we were before the court was the 13th.
And so, Ms. Fowler, at the beginning of the hearing, I've reviewed that proposed order, the contents of it. I'm not sure if that would be helpful if I were to review it again, so you know the substance of that order.
I don't see any service in Odyssey, and generally the clerk does note service has been performed in Odyssey when documents are delivered for me, and I'm able to see that, and I call the court and I pick up the documents.
Would you like me to review that order for you now so you know the substance of it?
Yes, Your Honor.
I'll read it in its entirety so you know what it says. Judgment creditor, Corey Reed, judgment debtor, Jolene Fowler, attorney fees, $250. Attorney fee shall bear interest at 12% per annum. Attorney for judgment creditor, Eleanor M. Cotto, attorney for judgment debtor, pro se. End of summary. Number 2, basis. This matter having come before the Honorable Michael H. Evans on June 13, 2023, on court's review of compliance with motion to compel entered on June 6, 2023, the respondent appearing by and through his attorney, Eleanor M. Cotto, and the petitioner appearing pro se. Court having reviewed the records and hearing argument from the parties, the court makes the following finding. Number 1, petitioner Jolene Fowler failed to comply with the oral ruling made on May 16, 2023, and the written order to compel on June 6, 2023 by providing the discovery request to respondent's attorney. Number 2, petitioner Jolene Fowler has not provided any further submission of discovery since May 16, 2023. Now, therefore, number 3, order. It is hereby ordered, adjudged, and decreed, number 1, petitioner Jolene Fowler shall provide respondent's counsel, Eleanor M. Cotto, with her address under the Washington State Address Confidentiality Program as soon as she receives this information through the service requirement as set forth in the June 6, 2023 order. Number 2, until respondent's counsel receives the above address information, petitioner Jolene Fowler will be served through the Cowlitz County Superior Court Clerk's Office, and it will be petitioner Jolene Fowler's responsibility to check with the Cowlitz County Superior Court Clerk's Office for any documents or filings submitted by respondent's counsel for petitioner. Number 3, petitioner Jolene Fowler shall provide full and complete answers to respondent's discovery request, including all requested attachments and documents by June 27, 2023. Number 4, respondent is awarded an additional $250 in attorney fees as set forth in the judgment section of this order. Number 5, the presentation of this order is on for June 20, 2023 at 9 a.m. Number 6, the court shall review the status of the discovery answers on June 27, 2023, and shall consider further sanctions if the requested discovery is not provided and is or complete. There's a place for a date, place for signature for myself. So any questions on that proposed order, Ms. Fowler?
One question that I have is, I'm confused as to how the judgment creditor is listed as Eleanor Cotto, because the other party is Corey Reed, not Eleanor Cotto.
Yeah, good question. Yeah, the judgment creditor is listed as Corey Reed, and then it just says the attorney for the judgment creditor is Eleanor M. Cotto. So yeah, you're right. It says judgment creditor is Corey Reed, not Ms. Cotto. Do you have any other questions?
The other question that I have is relating to discovery. Some of the items that Ms. Cotto's asking for, I'm being told by the administration for Social Security and then the federal government that they have already provided them answers, and I have no authority to override administrative rules.
So Ms. Feller, let me just pause if we could. I want to just stay focused on this proposed order that I just read to you. It sounds like you don't have any other questions about that. Is that accurate?
Regarding the order, as far as I'm aware, it has been ordered that I'm not to cooperate with state and federal agencies, or I will be sanctioned, payable to Eleanor Cotto. I am ordered to provide information so that they can further use it to seek funds for using my daughter. I am ordered to provide an address through the confidentiality program when it's available to me. So Eleanor Cotto can serve me for another client she has and start her proceedings with another case she has. That is my understanding.
So the order that I read to, the proposed order, do you have any objection to it? Meaning, did it get anything wrong that the court ordered? Is it an accurate summary of what the court ordered? And I'd be happy to review it again if you have any questions on any particular provisions.
I'm aware that the court ordered me to pay sanctions, and I believe that the order language is somewhat correct to what the court ordered.
Okay. And are there any specific things that I read that you're objecting to that you feel are not an accurate portrayal of what the court ordered?
I'm aware that that is what you ordered, Your Honor.
Okay. All right. So that order will be signed as presented, and so then we have the review for June 27th, a week from today, related to the discovery. So we'll review the discovery answers that have been propounded that Ms. Feller has a duty to respond to. So we'll review that on June 27th at 9 a.m. Any questions?
And my apologies to all parties for the delay. Juvenile was backed up.
Thanks. All right, Ms. Finney, do you have any questions or issues?
No, Your Honor.
Thank you. Ms. Fowler, any questions related to today's activities and next week's review?
The only thing that I wanted to make sure was that the state was served all current income information for Mr. Reed as well, because I do believe he was, I believe he was just recently married, and he has several changes and stuff that relate to support as well.
Your Honor, I will comply with any discovery request by the state, and I will provide the information as requested. So I don't believe that's properly before the court.
Okay, yeah, discovery is ongoing. There's each party has a duty if there's changes to seasonably update and provide updated discovery to the other party. So I'll trust that the parties will rely on the rules of civil procedure related to the civil rules related to discovery. So we'll see everybody next week, June 27th, 9 a.m. to review discovery answers from Ms. Fowler.
Thank you, Your Honor.
All right, that concludes the docket for today.